Hi, and welcome to today's Engaging for Missouri webinar. I'm Alice Roach from the Division of Applied Social Sciences at the University of Missouri, and I'll be your host today. With each of these 30-minute webinars, we intend to share research-based insights that leaders like you can apply in your own work to benefit and strengthen the state's agriculture and food system, hospitality sector, and communities. For today's webinar, Dr. Justin Dyer will present about constitutional rights during crisis. Before I invite Dr. Dyer to begin, I want to share a few housekeeping notes. First, we'll close the webinar today with a question and answer session. Those of you who connected to today's webinar via your computer can submit your questions in the chat screen. To open the chat, just click the chat button that you see at the menu at the bottom of your Zoom window. If you joined by phone, then you can send me your questions via email. My email address is roacham@missouri.edu. Second, all attendees are muted and may not start their video. Third, if you encounter any technical difficulties, then please let me know by submitting a comment in the chat screen, or you can also send me an email at roacham@missouri.edu, and I'll do my best to help you troubleshoot. Fourth, we will make a recorded copy of the webinar available to you. You can look for an email from Zoom that shares more about where you can access that recorded copy in about a day from now. You can also find an archive of all of our previous Engaging for Missouri webinars on our division's YouTube page. With that, we'll transition to the topic of today's webinar, which is titled Constitutional Rights During Crisis. Presenting on this topic is Dr. Justin Dyer, who is a professor of political science and the director of the Kinder Institute on Constitutional Democracy at the University of Missouri. So thank you, Justin, for presenting today. If you could please start your video and unmute your microphone, then we can begin your presentation.
Well, thank you, Alice, for that introduction. We're thinking about constitutional rights during crisis, and I wanted to begin with this question. If the state may conscript its citizens into military service and send them to war, may it do anything that stops short of that? This question has taken on new relevance in the age of Corona. State and local shelter-in-place orders have told residents under penalty of law that they cannot travel, cannot assemble peacefully in private or public places, cannot protest on government property, cannot worship in a building together or even in the parking lot in their cars, cannot have a proper memorial service for the departed. State authorities claim they're justified in restricting basic rights, at least temporarily, and I think in many instances they are. But that authority comes with a danger and a prudential calculation about how that power will be used by those who wield it, not just now, but also in the future. As a cautionary tale, consider, if I can advance my screen, consider Oliver Wendell Holmes's majority opinion for the Supreme Court in Buck versus Bell, a case from 1927, in which the Supreme Court upheld the right of state governments to forcibly sterilize people deemed by the state to be unfit for reproduction. Under these eugenics laws, common in the United States in the progressive era, state authorities sterilized some 60,000 people with near unanimous approval of the Supreme Court. With only one dissenting vote in Buck versus Bell, Justice Holmes wrote for the majority, quote, "We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped with incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime or let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes." And then he cites Jacobson versus Massachusetts, and then ends in his famous words, "3 generations of imbeciles is enough," end quote. And so we might ask, what is the principle exactly that would sustain cutting the fallopian tubes? For that principle, Holmes pointed to Jacobson versus Massachusetts, a case affirming the authority of the state to curtail rights during a smallpox pandemic. And so this brings into view the constitutional problem for us, I think. There must be some circumstances in which it is reasonable to restrict constitutional rights for the sake of the common good, especially during a pandemic. But allowing for such restrictions also requires that we draw and maintain limits. And maintaining this balance between individual rights and the common good isn't easy to do, especially if we factor in the ordinary vices of fallen humanity. Consider the reasoning in Jacobson versus Massachusetts, the case Holmes cited as direct precedent in Buck versus Bell. In the face of the quickly spreading contagion of smallpox, the city of Cambridge, Massachusetts required all residents to get a vaccination or face a fine. Jacobson refused to get vaccinated and appealed his fine, arguing that it violated his rights under the 14th Amendment to the Constitution. In his majority opinion, Justice Harlan noted that, as he said, quote, "The authority of the state to enact this statute is to be referred to what is commonly called the police power, a power which the state did not surrender when becoming a member of the Union under the Constitution." He also noted that the court had distinctly recognized the authority of a state to enact quarantine laws and health laws of every description. And in fact, states did this quite frequently, in cities as well, to combat contagious diseases. Then, citing Crowley versus Christensen, a case from 1890 about the state's authority to regulate or prohibit the sale of alcohol, Harlan then wrote, "The possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed by the governing authority of the country essential to the health, peace, good order, and morals of the community. Even liberty itself," he said, "the greatest of all rights is not unrestricted license to act according to one's will. It's only freedom from restraint under conditions essential to the equal enjoyment of the same right by others." He went on to say, "Upon the principle of self-defense, of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members." And so, returning to our original question, what are the limits of that police power? The court never says in any neat and tidy way. And so, to sketch that in, we need to do a quick civics overview. And then I want to conclude our brief presentation today with two examples of legal challenges that have been leveled against recent state stay-at-home policies during our current pandemic. When the Constitution was ratified in 1788, it didn't protect individual rights. A lot of people are surprised when they hear that. At least it didn't protect individual rights explicitly. Instead, it created institutions and it enumerated powers. The only individual right actually mentioned in the original text of the Constitution is found in Article 1, and it's about Congress's power to secure to authors and inventors the exclusive right to their respective writings and discoveries. And so it's really intellectual property rights that are mentioned in that original draft of the Constitution and the draft that's ratified. According to the understanding of the time when they're putting together this document, states would retain their broad police powers to legislate for the health, safety, and morals of the community, subject to their own constitutions and declarations of rights, while the national government would be one of limited enumerated powers. And so its framers thought that there would be no need for a declaration of rights on the model of what we found in the states. But critics of the Constitution disagreed, and they insisted on including specific guarantees of rights in the text of the Constitution. As a concession to the Constitution's critics, the first Congress proposed and the states ratified the first 10 amendments to our Constitution. These amendments protect certain basic rights that you're familiar with: the right to free speech and the free exercise of religion, the right to assemble peacefully, to keep and bear arms, to claim the protections of due process of law, and many others. But the 9th and the 10th Amendments also reiterate the logic of having a national government of limited and enumerated powers. In the 9th Amendment, you see this logic reiterated by its insistence that this is not a sum total of our rights, that those enumerated rights are not an exhaustive list, that the enumeration in the Constitution of certain rights shall not be construed to deny or to disparage others retained by the people. And then in the 10th Amendment, you have a reiteration of the logic of federalism, of states retaining the powers that they didn't grant to the federal government. And so in the 10th Amendment, you find this, that the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the people. Now, in the 19th century, the predominant understanding found in cases like Barron versus Baltimore from 1833 was that those amendments were limitations on the national government and not limitations on state governments. If you had a certain rights claim against your state government, it was a matter to be resolved by state law in state courts. And you might appeal to your state constitution or a state declaration of rights, but you wouldn't appeal to the amendments in the US Constitution to claim that your state had violated your rights in some way. Now, that understanding changed gradually in the 20th century through the development of the judicial doctrine of incorporation. This is the idea that the 14th Amendment's Due Process Clause incorporates or includes within it protections for the rights enumerated in the Constitution's first 8 amendments. And alongside this doctrine of incorporation, and predating it in some cases, is the doctrine of substantive due process, in which the court has held that there are certain unenumerated fundamental rights that are also protected by the 14th Amendment's Due Process Clause and protected against state governments. And so we now, at the end of this, in the early 21st, or really the first quarter of the 21st century, we interpret the 14th Amendment as protecting basic rights against encroachment by both our state governments and our local city governments. And then, of course, the basic rights in the Constitution give us protections against our federal government. But saying that is in many ways the beginning rather than the end of the inquiry. It's only after saying that state governments are restricted by the rights protected in the federal Constitution that we have to wrestle with the problem of limits on those rights under the Constitution. In what circumstances may government impose reasonable restrictions on the exercise of those rights for the sake of the common good? And that's really our challenge in thinking about this. The Supreme Court has addressed this problem through its creation of tiers of scrutiny for the judicial review of various laws or executive actions. And so if the court is going to review a law that's been passed or an action that's been taken by government and to review its constitutionality, decide whether it's constitutional or not, it often will employ tiers of scrutiny to say what kind of scrutiny it will use to look at a certain policy. When government restricts a fundamental constitutional right, the courts employ what they call strict scrutiny, which is the highest tier of scrutiny and the hardest for the government to satisfy. The framework developed over a series of cases in the 20th century is this: if government restricts a fundamental right, it must show that it has a compelling interest to do so. It has to show that the policy is narrowly tailored and that the policy is carried out in a way that is least restrictive of the right that's in question. And so what does this mean for a pandemic? Well, we don't know exactly. Courts and state and local officials are working through this issue in real time, and where exactly we land hasn't yet been determined. But there are a couple of cases that draw out and highlight these issues in a concrete way that we might think about as we're working through this. The first is in the case of Texas Governor Greg Abbott, in a case that went to the Fifth Circuit Court of Appeals. On March 22nd, Governor Abbott issued an executive order, like other governors had done, postponing all non-essential surgeries and procedures until April 21st, and included in that order elective abortion as a non-essential procedure. Governor Abbott quickly faced a legal challenge asserting that this order was unconstitutional as a violation of the right to abortion as articulated in Roe versus Wade in 1973 and then refined in Planned Parenthood versus Casey in 1992. Now, setting aside what you think about that issue or those cases, consider the reasoning of the Fifth Circuit in this case. Siding with Governor Abbott, a 3-judge panel of the Fifth Circuit relied heavily on the framework of Jacobson versus Massachusetts, that 1905 case that we began with. And that was the controlling precedent for the court, noting that under Jacobson and under that decision, quote, all constitutional rights may be reasonably restricted to combat a public health emergency. And so the court sides with Governor Abbott and cites Jacobson versus Massachusetts as the precedent here. But if it's the case that all constitutional rights may be reasonably restricted to combat a public health emergency, then the question is not whether the government has restricted a right, but whether it has done so reasonably. In the language of strict scrutiny, it's a question of whether the government has a narrowly tailored policy pursuing a compelling interest in the least restrictive way possible. And in at least some of the cases going forward right now, that standard may be hard to satisfy. As one final example for us, a group of citizens in California has brought a challenge to the Riverside County stay-at-home order, and that order in Riverside County prohibits, quote, all public or private gatherings, including, but not limited to, a church or any other indoor or outdoor space used for any non-essential purposes, including a church. Now, the folks bringing this case against the Riverside County order note that numerous other activities and industries are exempt from the order, provided people comply with other social distancing guidelines. People can go to Walmart, liquor stores, they can go to marijuana dispensaries, but there can be no gatherings specifically at church. One of the plaintiffs simply wanted to have a drive-in church service where parishioners wore masks, stayed in their vehicles, and parked 6 feet apart from each other. In an important case called Oregon versus Smith in 1990, worth revisiting, the Supreme Court held that laws of general applicability that are neutral with respect to religion can be enforced against religious dissenters just like everyone else. If there's a general and neutral ban on gatherings, then you can't have gatherings for religious reasons either, according to that precedent in Oregon versus Smith. But one might ask whether the government policy is really neutral with respect to religion when it prevents all church gatherings, even ones that comply with other public health and social distancing guidelines, even as it allows all sorts of other gatherings and activities. If that is the case, then the government would have to show a compelling interest in specifically restricting the free exercise of religion, and then demonstrate that there's no other way to achieve the public purpose without putting fewer restrictions, or while putting fewer restrictions on the exercise of this fundamental constitutional right. That, at least, is the argument that's being put forward in this case, and we'll see how the courts deal with this. When we peel away the judicial glosses and doctrinal formulas, the question at the end of the day is this: is this government policy and its particular application as a response to this pandemic at this moment justified? Is it reasonable? And there's, of course, a second related question, and it's who gets to decide. And the answer in our political system is we do. At least we will, through a back and forth conversation among legislators and citizens and executives and judges. And the judges, as they consider these questions, will do so within this jurisprudential framework for constitutional rights that we've built over the last century and a half. It's an important question, and one that we're continuing to wrestle with. And I would be very happy to take questions if we have some questions at this time.
Excellent. Thank you, Justin. We do have a few questions that have been submitted. If you would like to submit a question, you can feel free to do that either in that chat screen or also send me an email at roacham@missouri.edu. So our first question here is getting at this idea that in some states there have been bans of outdoor activities that involve social distancing, like fishing, hiking, and so forth. So what are your thoughts about those types of bans, given that they do allow social distancing?
No, so I'll say that I'm not at all an expert, a public health expert, and so I don't want to pronounce anything about the public health side of it. But on the constitutional question, I think if we went through this framework, you would have to ask something about the compelling interest that the government has and whether it's satisfying that in this narrowly tailored kind of way. And if we approached it with those kinds of questions in mind, I think there probably would be a lot of activities that we might think that the policies are overbroad, that they're catching within it all sorts of things that they need not catch within it. So it might be the case that going out and fishing, for example, gardening, whatever you were doing, if there's some activity that you can maintain the social distancing guidelines, if that's how we prevent the communication of the disease, then there might not be a good rationale or compelling interest in preventing citizens from doing that.
Okay. This question is getting at the idea that how should we think about the fact that some deprivations of liberty are temporary and others are permanent?
Yeah, I think that's a fair question, and one that we have to think about. So on the one hand, you have these stay-at-home orders that are theoretically temporary, that all of these restrictions on rights or limitations on rights are ones that we look forward to having lifted very soon, or at least people think we hope they'll be lifted very soon. It might take on a different kind of analysis if it turns out that, no, this is not something that you endure for several weeks, but rather that you endure for several months or 18 months or years at a time. And if that's the case, the analysis might look very different, actually, in terms of what we're willing to tolerate and what we think is a reasonable restriction or limitation of an exercise of a constitutional right.
Great. Here's a question concerning whether local leaders can essentially kind of override federal or state enforcement. So if local leaders decide, for instance, not to enforce prohibitions on gatherings at religious institutions like a church, can the state or federal government enforce this?
State government could. The federal government, I don't think, can. And this goes back to the Civics 101 portion of what we were talking about. But the Constitution, the way that it sets this up is it delegates or it enumerates powers to the federal government. And it's a government of limited enumerated powers. And then the police powers are retained by the state. And the state constitution will then allow for the devolution of authority on down to cities. And so cities are always subject to the state authority, and the state government could, subject to the laws on the books and the Constitution in place, override city ordinances. The federal government, however, is limited, and it's limited to things that go across state lines or affect commerce among the several states or the relationship of the United States with foreign countries. And so as I understand the state of play right now, the federal government has some tools. Some of it can be through guidelines that they hope that states will comply with. Some of it will be through our immigration and naturalization laws and restrictions on who can enter the country. And some of it will be with respect to a delegated authority to the CDC with respect to travel among the several states. And so if people are entering or leaving one state and going to another. But with respect to activities that are wholly local, that happen within the borders of one state and aren't affecting other states, then that's a state level issue. And then that's going to be sorted out between city authority and state authority. Now, with that said, it's difficult to untangle all of those things because you have a disease that spreads very, very quickly and spreads across state borders. And so that'll be one of the questions I think courts are looking at is there any meaningful way to say that there's something that is truly and wholly local in this kind of circumstance?
Sure, understandable. Here's a question. When you say that we decide about our rights and limitations on them, do you mean that each state will decide per the 10th Amendment?
No, not necessarily. I mean, we as a people. And the reason why I said that is because I was tempted when I was first writing those notes to say that the courts will decide. And in some sense, we're very accustomed to thinking about constitutional questions as being settled by courts, or courts are deciding these things. But I think the reality is more nuanced, and it's that the courts, of course, are able to decide very specific cases that come before them. But before the case comes before a court, you have historical precedent that's built up over time. You have multiple courts deciding questions, and you have a process where state authorities are passing orders and stay-at-home restrictions. The federal government's weighing in on it. There are CDC guidelines. Citizens are protesting or complying. And so there's this dynamic process where all of these issues are being sorted out together with the media in conversation, with local authorities, with citizens. And then finally, the Supreme Court or the federal courts are part of that process. But I think it wouldn't be accurate to say that they're the only part of the process, or that courts just simply tell us the answer to the questions. So we decide, but we decide collectively, not just as states, but I think as a country as a whole. And even the state governments are in conversation with the federal government on this issue, and governors are in conversation with each other. So it really is a collective enterprise.
Sure. Here we have a question about what do you make of Attorney General Bill Barr threatening legal action against governors? Isn't that contrary to the 10th Amendment?
Yeah, that's an interesting question. So the question of federalism and the authority here. And I think this is one of those issues where you have to think through what the authority is at the local level, what the authority is at the federal level. And I think what Attorney General Barr would likely say is that if there's a constitutional right in question, and if the 14th Amendment prevents a state from violating individuals' constitutional rights, then there's no reason why that has to be left wholly up to the states. In other words, it ceases to be a federalism issue to the extent that the states are violating individuals' rights. When we might disagree about that in terms of whether the right in question is actually being violated or not. But I think that would be the logic of the Attorney General's position on that.
Okay. This person is bringing up another precedent, the slaughterhouse cases that stated that rights to commerce or business are not covered in the Constitution. So have any suits or arguments considered that reasoning?
Yeah, the slaughterhouse cases is famous for really limiting how we interpret the privileges or immunities clause of the 14th Amendment. And this gets into the weeds a little bit in terms of that. But the 14th Amendment also says that states won't abridge the privileges or immunities of citizenship. And there was at least one avenue for us to argue that our fundamental rights are protected by that clause in the Constitution. In the slaughterhouse cases, the court rejects that interpretation. They give a really limited understanding of privileges or immunities. And that's one of the reasons why we've turned to the due process clause. And the due process clause textually isn't the most obvious place to root a discussion of fundamental rights. It says that the state may take your life, liberty, and property as long as it provides you the due process of law. But we've interpreted that phrase and that clause in a way that imports to it protections for basic fundamental rights. There has been some movement. If you watch Justice Clarence Thomas is probably the most outspoken proponent of this on the Supreme Court right now. But Justice Thomas, even in some of the recent cases from this term, has advocated a return to the privileges or immunities clause and a resurrection of or revisiting of the issues in the slaughterhouse cases.
Okay. This question is getting at the interest of the greater good. So could you address that interest and parallel these restrictions to, for example, eminent domain?
Yeah, that's an interesting question. The question of eminent domain and the powers that we might have and individual rights versus the common good. And at the founding era, they believed in property rights, of course, and property rights are protected at the state level. But there was a recognition that property rights also had to yield to the good of the community when the community needed to use of certain property. And there's a protection in the Bill of Rights that says that property won't be taken for public use without just compensation. And so there's this idea in the Constitution itself that, yes, of course, the community might have need of your property to build a highway, to build a school, to build a public place. But in order to take that property through eminent domain, the government has to provide just compensation. So there's a provision of justice that's recognized even with respect to eminent domain and the good of the community, that the community cannot simply trample individual rights, in this case, the individual right to property, without considering the requirements of justice. And in this case, it would be just compensation for the taking of that private property.
Okay. This next question is regarding essential personnel. So has a court or government agency clearly defined what is essential?
I'm not aware of any court that has clearly defined what is essential versus what is non-essential. The stay-at-home orders will list what they consider to be essential, although I don't think that ever comes with a definition with respect to essential. I've seen some governors say things like, if it's clearly designed to protect and promote life or health or something very broad in that sense. But then you'll have a more specific list of the kinds of businesses or industries or stores that are allowed to remain open because they're essential. And then in some cases, like the Riverside County order that I mentioned, a very specific list of things that are deemed to be non-essential. And I think this is one of those areas where it really does reflect a different ordering of values in terms of what we consider to be essential or non-essential, and different prudential calculations in terms of what we think should remain open or should be subject to the stay-at-home orders.
Okay. More about those stay-at-home orders. Some cities and counties have had indefinite orders. Do they have to put a timeline on them at some point, or can they just say indefinite until they reach a decision otherwise?
I'm not aware of any specific case in which a court has said that they have to put a time limit on it. I do think it's a reasonable thing for us to be thinking about. If we're going to have restrictions on rights in this way, must they be temporary? And surely you would think, yes, they have to be. What does that mean exactly? Is there a specific timeline? I don't know that we would ever have the ability to put a specific timeline on it because we don't know how long the emergency lasts. We don't know what the crisis is. We don't know what it will take. And so it would be very, very difficult to say you can only do this for 120 days and then at that time no more. On the other hand, though, it can't be the case that it would just simply be a permanent restriction on liberty. The kinds of things that the Supreme Court has recognized as unenumerated rights include things like the right to travel, and for the enumerated rights, things like the right to free speech or religious liberty or due process of law and all sorts of other things that I would think it would be very, very dangerous to say that it could be simply indefinite with no timeline or horizon in sight.
Great. Well, thank you so much, Justin, for answering so many questions. We do have quite a few more questions. Would you be open to attendees reaching out one-on-one to
Sure.
further the discussion?
Sure, no problem.
Okay, excellent. And if you can direct those questions to me, I'm happy to forward them on too. So that will go ahead and wrap up today's webinar presentation. Thank you for joining us. When you exit Zoom, you'll see a post-webinar survey load in your browser. Please consider responding, as we'll use your feedback to improve the webinar experience and also brainstorm future webinar topics. Again, you should receive a recorded copy of today's webinar in about a day from now via your email. Tomorrow, on Tuesday, April 28th, Dr. Scott Brown, who's an Associate Extension Professor of Agricultural and Applied Economics and CAFNR's Director of Strategic Partnerships, will present an Engaging for Missouri webinar about the economic turmoil in livestock markets. So thanks again for joining us, and I hope you have a nice day. And thanks so much, Justin.
Yeah, thank you.